Hi, my name is Derek McKee. I'm a law professor at the Université de Montréal, and this video capsule is about the relationship between international law and Canadian administrative law. I'm going to start by saying a few words about the sources of international law and how they're received into Canada's domestic legal system. I'm then going to talk about how the rules of international law, and particularly international treaties, can play a role in administrative decisions. I'll do this by distinguishing between situations where a treaty has been implemented into domestic law and situations where the treaty has not been implemented. And finally, I'm going to highlight some of the ambiguities surrounding these issues, mostly stemming from the fact that it's not always clear to what extent we can consider that a treaty has been implemented into Canadian domestic law. And that's particularly the case with regard to human rights treaties. So to begin with, I want to say a few words about the relationship between international law and the Canadian legal system. I'll summarize this material very briefly. If you've already taken a course on public international law, this material will be familiar to you, will be a kind of review. If not, bear with me. I'm gonna try to provide a rapid summary, although it's important to recognize that there's much more to these issues. So the important thing I want to highlight is that the two most important sources of public international law are treaties and custom. And when it comes to the implementation of these sources into Canadian domestic law, Canadian law deals with these forms of international law a little bit differently. With regard to custom, the official position is that custom is automatically applicable in Canada. The Supreme Court made this more or less clear in the 2007 HAPE case, and then reaffirmed it, made it perfectly clear in 2020 in the case of Nevsun v. Araya. And what this means is that by default, custom is directly applicable in domestic law. However, it's also important to keep in mind the principle of parliamentary sovereignty, which implies that the legislature can always override customary international law. But it's generally considered that to do so requires clear legislative intent. Otherwise, customary international law applies in Canada. With regard to treaties, the approach is a little bit different. You might know that treaties go through several stages of approval. From the Canadian perspective, the executive has to go sign the treaty. Then a member of the executive will also ratify the treaty. And finally, Parliament or a provincial legislature has to implement the treaty into domestic law by enacting legislation. And it's only when one of these legislative bodies does this that the treaty becomes binding from the perspective of Canadian law. This implementation process has been clear in Canada since the 1937 Labour Conventions case, which was a decision of the Judicial Committee of the Privy Council. Why is the process so complicated when it comes to treaties? Well, essentially, there are separation of powers issues. It's generally said that if treaties didn't have to be implemented through legislation, the executive would be able to make laws directly, bypassing the legislature by going and signing a treaty with another country. There are also problems related to Canada's federal system. The fear is that the federal government might encroach on provincial authority by signing treaties with other countries. And that was actually what was at stake in the Labour Conventions case. In that case, the federal government had signed treaties, ILO conventions related to labor standards, and tried to implement them through federal legislation. But the Privy Council held that this legislation was ultra vires parliament. Now, it's also important to note that regardless of whether a treaty has been implemented into Canadian domestic law, there's also a presumption of statutory interpretation that holds that statutes are supposed to be interpreted in a manner consistent with international law, and in particular with Canada's obligations under international law. And actually, this is a presumption that applies to customary international law as well. In this capsule, I'm going to focus on treaty law and leave aside custom for the moment. Well, why am I going to do that? Well, essentially because treaty law is much more abundant than customary law, and it touches on a broader range of subjects in much greater detail, and therefore tends to play a greater role in Canadian domestic administrative law. So yes, to return to the theme of this course, what does all of this have to do with administrative law? Well, international law is important for administrative law because international law can have an impact on the acts of government authorities and other members of the executive. This most often happens indirectly when the executive acts on legislation that is meant to implement international law. It sometimes happens directly, however, if the executive tries to implement international law itself. And different kinds of issues can arise in this process. Certain kinds of issues arise when a treaty has been implemented into domestic legislation, and other kinds of issues arise when it has not. So I'm going to talk about those two scenarios separately. First, I want to talk about what happens when a treaty is implemented into Canadian law. A classic example of this scenario comes from refugee law. In order to be recognized as a refugee under Canadian law, an asylum seeker has to satisfy the criteria set out in Section 96 of the Immigration and Refugee Protection Act. But the criteria in Section 96 of the IRPA are taken directly from the 1951 Refugee Convention. In fact, this statute is how Canada has implemented that treaty. And Canadian courts have consistently held that the executive can't just treat Section 96 of the IRPA like any other statutory provision. It can't just interpret and apply the Canadian statute in a kind of nationalist bubble. Instead, it has to consider the treaty that is behind the statute, and it has to consider how this treaty has been interpreted when it interprets the statute. In a case from 1998 called Pushpanatan, the Supreme Court reviewed a decision of the Immigration and Refugee Board concerning the interpretation of identical provisions in the former Immigration Act. And in that case, the court made a point of looking to international legal sources to determine how the Canadian statute should be interpreted. The court also reviewed the IRB's decision on a correctness standard, in part because it considered that when it comes to international law, courts have as much expertise as administrative tribunals like the IRB. Now, what the court said about standard of review in Pushpanatan in 1998 is now clearly out of date. As you've seen in the 2019 Vavilov framework for standard of review on judicial review as opposed to a statutory appeal, government officials' legal interpretations are subject to reasonableness review unless the question falls into one of the rule of law categories that calls for correctness review. And so far, international law has not been recognized as one of these categories. So unless there's something else to trigger correctness review, the reasonableness standard can apply to government officials' interpretation of statutory provisions that implement international law. Indeed, you'll remember in Vavilov itself, there was an international law issue. If you'll recall, Alexander Vavilov was born in Canada, but his parents were Russian spies. The registrar canceled Vavilov's Canadian citizenship under a provision of the Citizenship Act that says that children born in Canada don't get Canadian citizenship if their parents are diplomats or other representatives or employees of a foreign government. The registrar assumed that this provision was self-explanatory, that it could be taken at face value, and she concluded that Vavilov's parents, as spies, were representatives of a foreign government, and therefore Vavilov should not get citizenship. But the court pointed out that this provision did not exist in a vacuum. It had to be interpreted in light of another statute as well as a couple of international treaties. The other statute in question was the Foreign Missions and International Organizations Act, which actually implements two international treaties, the Vienna Convention on Diplomatic Relations, as well as the Vienna Convention on Consular Relations. And the interpretation of that statute, the Foreign Missions and International Organizations Act, as well as these two treaties, make it clear that the provision in the Citizenship Act was only meant to deny citizenship to children whose parents had the benefit of diplomatic immunity. And obviously, as spies, Vavilov's parents had no such immunity. So according to the court, the fact that the registrar ignored this legal context, including the international legal sources, made her decision unreasonable. In fact, in its general pronouncements about the reasonableness standard in Vavilov, the majority of the court specified that, in some administrative decision-making contexts, international law will operate as an important constraint on the administrative decision-maker. So in Vavilov, although we're in the realm of reasonableness review rather than correctness review, the administrative decision-maker still has to pay close attention to the international legal sources of the statute. So Vavilov is a good illustration of what can happen when treaties are implemented into domestic law. Now, different issues can arise when executive action is influenced by a treaty that has not been implemented. You'll recall that I mentioned a few minutes ago that Canada sometimes signs and even ratifies treaties and then doesn't implement them into domestic legislation. A good illustration of that scenario comes from the 1999 Baker case. You'll recall the facts. Immigration officers refused Mavis Baker's request for a humanitarian and compassionate exemption that would have allowed her to stay in Canada. Baker challenged the decision on both procedural and substantive grounds and eventually won. And international law played an important role in both aspects of the decision. That's because there is an international convention, the UN Convention on the Rights of the Child, that says that public authorities must give primary consideration to the best interests of children in decisions that affect them, especially when there's any decision that might lead to children being separated from their parents. Canada has signed and ratified this treaty, but Canada has not explicitly implemented the treaty into Canadian law. Baker argued that this treaty had an impact on both the procedural and the substantive aspects of her case. Procedurally, she argued that by signing and ratifying the treaty, the government had created a legitimate expectation. The court ultimately rejected this argument, however. Substantively, Baker argued that the convention had an impact on the factors that the minister had to consider as part of the discretionary decision. And this argument the court finally accepted. The court held that this treaty and other international human rights treaties were sources of values that had to inform the exercise of discretion in humanitarian and compassionate decisions. However, it's important to note that the court was not unanimous on this particular point. Justice Iacobucci wrote a concurring opinion that was signed by himself as well as Justice Corey, where he stated that he agreed overall with Justice Leroux-Dubé's majority opinion, except with regard to her use of international law. Justice Iacobucci said that requiring the executive to consider a ratified but unimplemented treaty would allow the government to do an end run around Parliament, basically implementing a treaty by the back door. Now, at the beginning of this capsule, I said that there were different issues depending on whether Canada had implemented the treaty into its domestic legislation or not. But another problem is that it's not always clear whether this implementation has occurred. Sometimes it's clear that Parliament or a provincial legislature has enacted a statute with an international treaty in mind. That's the case with the Refugee Convention that I discussed earlier, for example, or with the Vienna Conventions that were at stake in Vavilov. But sometimes the influence of the treaty is implicit and not explicit. And sometimes what the statute says is quite different from what's in the treaty. So administrators and the courts that review their decisions have to decide just how much they should look to the treaty in order to interpret the statute. This question can give rise to some tricky problems of statutory interpretation, which I won't get into for the purposes of this capsule, but just be aware that those issues can arise. I also want to note here that this ambiguity about how domestic implementation works raises a particular set of issues in cases dealing with human rights. When it comes to international human rights treaties, like the International Covenant on Civil and Political Rights or the International Covenant on Economic, Social, and Cultural Rights, Canada has often signed and ratified this kind of treaty, but has not formally implemented them in the form of a statute. Instead, the Canadian government has taken the position that Canada's domestic legal system already satisfies the requirements of the treaties. In particular, the fact that Canada has the Charter of Rights and Freedoms. So what does this mean for administrative law? Well, we know that government officials in Canada have to respect the Canadian Charter of Rights and Freedoms in their administrative decisions. And if the Charter is viewed as an implementation of international human rights law, does this mean that the Charter has to be interpreted to be consistent with international human rights law? That someone who is challenging a government decision on grounds that it violates the Charter could also point to a provision in one of the treaties and argue that it's constitutionally binding on the government. So far, Canadian courts have waffled on this question. There are some cases where they have said that international human rights law should be used as a kind of a baseline, and that the Charter should be considered to protect rights at least as much as international law. But more often, Canadian courts have looked to international treaties as persuasive sources for interpreting the Charter without treating them as binding. So as you can imagine, this position has come under a lot of criticism from some lawyers and scholars. Now, this debate about international human rights law has multiple dimensions. It's not only relevant for administrative law, but can also come up in classic constitutional law cases where the question is about the constitutionality of legislation. It's also important to note that cases about human rights sometimes involve not only treaty law, but also international customary law. For both of these reasons, I'm not going to expand on the topic for the purposes of this capsule, but I wanted you to be aware of it so that you'll recognize this set of issues if you happen to encounter them again.